Hi, everybody. It's Monty here. This is a webinar on the transition tax ruling the judge issued a week and a half ago, and the road ahead after the ruling, which was not in our favor, as you know, and the road ahead regarding that lawsuit and the guilty lawsuit, and also developments that we see happening in the Democratic Congress and with Biden regarding guilty and how that will affect us. So that is the topic of today. This event is somewhat unique in that I am doing it recorded rather than having it live. And the reason I'm doing that is because I want to be able to freely discuss certain slightly more sensitive issues regarding the lawsuit so that I can share that with you, you guys and gals that have supported us, the movement. And I do know for a fact that certain people who did register are from US media and suspicious other places. And I do not want this information to get out and be in the public domain. So I decided that I would do it like this and would send it only to people that I know for sure are friends of our movement. So I don't envision doing this again in this way, but this time I thought just for the safety of our litigation that we take the precautions necessary. Yes, so this is the subject of today. And so here's the agenda, the transition tax ruling on our motion for judgment. That was the final motion of the case. And the judge awarded the judgment to the government, as we will see. So we'll talk about that. We'll talk about the road ahead for the transition tax case. We'll talk about what the impact of that, if it all, has on the guilty case. We have two different cases. And of course, as I said, we'll talk about what's happening with guilty in the legislative and legislative branch and the executive branch, meaning Treasury, as well as international news. And if you have been following, there is a lot of things happening in this world of guilty on the international front as well. I took a 1-minute break. You may have heard the siren in the background. Today is the Holocaust Remembrance Day. It's, I think, one of the 2 or 3 times a year when there's a siren and when we remember things in the past. And today we remember the 6 million Jews who were murdered in under the Nazi regime. And we say never again. Anyways, that's a part of Israeli life that just happened to intersect with this webinar. So let's continue. So first of all, before we talk about the transition tax, it is very important to understand a little bit of what it is, what it means to file a lawsuit in federal court and understand the litigation. First of all, federal court is a court of limited jurisdiction, meaning only very certain things can be heard in federal court. Federal disputes around involving federal laws, lawsuits between states. It is a court, you might say, of limited jurisdiction. What that means is that the court will always have to answer. The first thing is, does it have the authority to hear this case? Okay, and those are words you have heard, I'm sure, many times regarding lawsuits that expats file, that it was dismissed on a technicality for lack of standing, okay, or for lack of jurisdiction. Our case has faced these challenges time and time again, and the reason every single lawsuit in federal courts does is because, again, federal court is a court of specific jurisdiction. It only hears certain things and in certain conditions. Okay, so what does it mean standing in jurisdiction? Okay, so basically, the first of all is the standing. Can I even bring this lawsuit? Okay, does Monty have the right to bring this lawsuit? Okay, let's say that the law said that only women can bring this lawsuit, uh, and but I've been injured exactly under the law, but I'm not a woman. Therefore, if I file a lawsuit, the court, even if I'm 100% injured and the government was wrong, or whoever I'm suing is wrong, the government is wrong, I do not have standing. I am not the right person to hear this, to bring this case. And at a high level, what does standing mean? There's three elements that I, as a person bringing the lawsuit, have to establish. Number one, that I have been injured, Number two, that the injury was caused by a breach of duty of the defendant or the government in this case. And three, that the court can actually solve the problem or redress my grievances. Those are the three elements of standing, okay? And it's called constitutional standing or Article 3 standing because it's in Article 3 of the Constitution that you have to have standing, and those are the three elements of it. And we will get into that a little deeper later on. The other thing is jurisdiction, which we will also hear about later on, specifically to this case. And that is, even if I conceptually have been injured, it was caused by some, and the court can do something about it, can the court even hear this case, even if I'm the right party to bring it? Okay, for example, if I sue under state law, then the court does not have jurisdiction to hear this lawsuit because, as I said, a federal court can only hear very specific things, and even then it can only hear specific things from the right party who has standing. So these are two procedural things that a court can dismiss a case at any time. Okay, as I said, standing in jurisdiction are issues that can be raised at any time, early on, or even 1 minute before the judge renders judgment, as was the case here. And it can be raised at any time. And if they don't exist, if there is no standing or no jurisdiction, the court must dismiss the case. Okay? And only if you satisfy all the requirements of standing do you proceed to the merits. So there are procedural things that have to be overcome, and 90%, or in our case, 100% of the case only went around the procedural things, and the case never got to the merits. Many cases do not get to the merits. Okay? Okay, so we'll talk first of all about jurisdiction. Does the court have the authority to hear this case? Well, I sued under the Regulatory Flexibility Act. That is a federal law. So by definition, the court has jurisdiction. This is a federal law that I was suing under. So the jurisdiction, at least for phase one, the initial checklist is yes, there is jurisdiction. And what is this Regulatory Flexibility Act that I sued under? Well, it's a very unknown law that has basically never been used against Treasury or major agencies. It's been used once or twice with fisheries, on ponds and fishermen fighting over fishing rights after the Department of Interior passed a rule that governs how you fish. This is a law that protects small businesses from regulations passed by the agencies, the Treasury, the Department of Interior, the Department of Justice, or whatever. When an agency, the executive branch, passes a rule, this law was passed as a way to force these agencies to make sure they do not harm small businesses, or to go out of their way, at least, to exempt or provide an easier way for small businesses to comply with these laws. Why was this law passed? Well, because many times, as the case of ours, rules and laws like the transition tax were not passed because of the small businesses. They were passed because Google's and Apple's were holding $2.5 trillion overseas. The government wanted to get that money. They passed those two laws, and then the Treasury passed regulations interpreting the law in a million scenarios, and those regulations have the weight of law. But when they do that, they must, the Treasury, not the legislature, not Congress, Treasury must comply with these laws, because many times small businesses are really hurt by laws which they have nothing to do, they're not part of the problem. And because small businesses are the vast employers in America, this law was passed in 1980 and then amended in 1996 to make sure that all agencies, including Treasury, comply with these laws, and they set forth, we'll see in a minute, a large amount of bureaucratic processes to see what the problems are for small businesses, whether they even can comply with these things, if they're too complicated, whether there's ways to narrow the law, or maybe even exempt them from the law or the rule. Okay, so that's why the Regulatory Flexibility Act was passed. And is it used much? No, it is very rarely used, and we'll see why. Yes, we'll see why in a little while, but it has to do with the nature of small businesses who just don't have the money to organize and to spend time pursuing these things. Okay, so that is the law that we sued under, a federal law. There was jurisdiction. And what does this law say? Well, we're going to look at the key parts of the law. And basically it says that whenever an agency issues a proposed rule, then it must go through what is called an initial regulatory flexibility analysis, meaning an in-depth analysis looking at how these regulations will impact small businesses. And small businesses is defined up to $25 million in revenue for 1,000 employees. So it covers a lot of businesses. So imagine the GILTI or transition tax or any other work safety or pension rules. These impact a lot of businesses. Okay, so here is this is the law. You're seeing the law here, and this shows you just part of what the agency is supposed to do before they issue a proposed regulation. Okay, and that includes looking at alternatives to how small businesses should comply, including exempting them from the coverage of the rule. That is in line with the spirit of and the purpose of the Regulatory Flexibility Act, to make sure that small businesses are not hammered by a uniform enforcement of the law, especially where we're not the ones causing the problem. Okay, so this is one thing they have to do in issuing regulations. And you can ask how I even found out about this Regulatory Flexibility Act. Well, when they came out with the proposed regs in August of 2018, I couldn't understand much because it was a 250-page document of really complex things. But I did come across a section that said the Regulatory Flexibility Act does not apply because this law and these regs do not impact small businesses. Okay, so I started to look, well, what is that Regulatory Flexibility Act and why did they put it in there? So you'll see in a minute why they put that in there. Okay, so this is what they have to do when they issue a proposed regulation. And then when they issue a final regulation, they have to do another analysis, which includes all those elements, including talking about all the alternatives they considered, like the exemptions and all other things, and then provide a factual and policy and legal reasoning why they did not choose these various alternatives to the to exempting or helping out small businesses. So this is something that takes a pretty significant amount of resource. The Small Business Administration has produced a 100-page document about how to comply with the RFA. They've sent it to the agencies. So it is a pretty, at least on paper, it looks to be a pretty significant obligation that the government, Treasury in our case, had to comply with before they issued the proposed and final regulation. And especially here, because when they came out with this in August of 2007 and 18, it was already after hundreds of us had mailed Treasury. I went there, I met with them, they gave us 2 exemptions, if you remember, in early on in 2018. So they were very aware that small businesses were devastated by this transaction, by the transition tax and by Guilford. So before they even came out with the regulations, they were on notice and they gave us relief that small businesses were really hurt by this. Okay, now, but there is one escape route, how to get out of jail free card, which is in section 605, which says, if the head of Treasury or the head of the agency certifies that the rule will not have a significant impact on a substantial number of businesses, then they don't have to go through those analysis and exemptions and all that kind of stuff and even do anything. And wouldn't you know it, lo and behold, Treasury does not, in 99.5% of the case, always certifies that the rules will not have an impact on small businesses. Not because they won't, but they say, well, look, we don't want to comply with this. And they've been doing this for decades. And indeed, the GAO, the General Accounting Office of Congress, in 2016 came out with a report, an independent report. This is the federal government, that said that the Treasury does not comply with this law 99.5% of the time. They just certify it will not have an effect, and therefore they don't have to do any of the analysis. Okay, so the law is good, but there is this get out of free card that they have, and it's not only get out, I mean, they have to certify. So when they came out with the regulation, the proposed reg in August, Mnuchin, 60 days after he himself granted us a 1-year delay in the transition tax, he certified this. Okay, so I very quickly, I don't know, I found this out in August, and I immediately asked him and Chip, you guys, how can you certify that when you know that we were hammered by this? And then I started looking at the requirements for certification. And as it says here, to certify, they have to provide a factual basis for the certification, meaning they have to give analysis why they certify. And here, again, in that SBA document, there are specific like 20 pages of what you have to do in order to certify. You just can't say, oh, it won't have an impact, even though that's what the Treasury says. You have to go through a lot of hoops, and the congressional history of the RFA is very clear. There's no, you cannot just boilerplate certify, boilerplate. You have to do the work, and if you have to go through the hoops and check if it does impact. Of course, they never do that. And so basically, That is the nature of the statute, which provides a lot of safeguards to us small businesses. Okay, now what is the hammer or the stick that we have? Well, if a small business or a small entity is affected by, is hurt by a final action, meaning you can only sue once the final regulations come out, then you can file a lawsuit. And this is very powerful because many acts, like many laws, like the Paperwork Reduction Act, does not give a right of a private individual to bring a lawsuit against the government. But here it does. And why does it? Initially, when this law was passed in 1980, it did not. There was no private cause of action. You couldn't sue for a violation. Okay, but in 1996, they realized, Congress, that all the agencies were just certifying, and so they added this, that you can sue. And if you look under exactly what you can sue under, you can sue under 604 if they didn't comply correctly with the final regulation, the final analysis, or 605B. What is 605B? That's the certification. If you think that the certification was issued without reasonable basis, key here is without reasonable basis, you can file a lawsuit challenging the certification, that the certification was faulty, should not have been given, or was given without the proper work, without the proper work done. You can sue, and if you win, look at number 4, the court shall mandatory take corrective action, including but not limited, remanding the rule back and deferring the enforcement of the rule against small entities. So one business can sue, and if they win and prove that, and if they can get by the procedural challenges and prove that the court, that the agency did not act reasonably in their certification, meaning they didn't have reasonable grounds to believe that it was right, okay, then the court must do those things, okay? So that is a very powerful law in theory, okay? And supposedly, any small business can bring a law challenging all those regulations conceptually. In reality is, why is the RFA never used? Well, it's pretty clear, knowing the way the system works in America and knowing the nature of small businesses. First of all, small businesses, we don't have time and money, okay? How are we gonna get money and time to start filing lawsuits against the federal government? As you saw, it took 2 years of my time. I'm a tax attorney and I love this challenge, and I like a good fight if it's a good fight. And so I decided to challenge it, but it has never been used against these powerful agencies other than like a fish pond. And because it takes a huge amount of time. Google can throw $1 billion here, $1 billion there, but a small business can't. And how do small businesses get together and decide? Those are very, very difficult things to do, okay? That's why this law has never been used, because of the nature of small business and because who wants to fight the IRS, okay? Not many people want to stick their neck out and say, IRS, I'm filing a lawsuit against you. And it basically is a class action, because if I win, then I win for everybody. So they're going to the government will put up a huge fight. You're going to be stuck with this for a couple of years. And even though the law is pretty simple, if they didn't comply with the RFA or they certified wrongly, all you have to prove is that, number 1, you're a small business. What do you have to prove to win? That you're a small business, that the government did not comply with the proper certification standards, and that you were injured. Those are the three things you have to prove on the merits, that you're a small business under the RFA. Number two, that the government certification was wrong or unreasonable. And number three, that you were injured. Those are the three things you have to prove on the merits. But you have to get to the merits to do that. Okay? Okay. So what basically happened in our lawsuit? Okay, well, we filed a lawsuit after the final regulations were approved. You cannot sue until then. That was in January of 2008 and 19, 2 years ago. Okay, the first thing that the government will do in almost all the cases, they'll file a motion to dismiss for lack of jurisdiction and standing, always, because they many times win. The judges are, they don't want to grant easy victories against the government. There's a serious impact for these lawsuits if they're allowed to win against the government so easily. So the government, and if the government loses, of course, they'll appeal. So the judge wants to make sure that he doesn't give an easy win, or it's not lawful, because he or she's going to face an appeal, certainly by the government. Okay, so that's what they did in this case. And now let's look at what claims they made. Okay, the first one was, as I said, jurisdiction we have conceptually. Why? Because it's a federal law, and we were challenging a regulation of Treasury. Okay, so they said it is true that the RFA is a federal law, but there is what is called the Anti-Injunction Act, which says no suit for the purpose of restraining or assessing tax shall be maintained in any court by any person, whether or not blah, blah, blah. Okay, so even though this is a federal law, this law seems to say that if the purpose of this lawsuit is to restrain the collection or assessment of a tax, the court does not have jurisdiction. So even though conceptually the RFA does give the court jurisdiction, in the area of taxation, the law says, court, you do not have jurisdiction if it will restrain trade, restrain the collection of tax. And because the courts have been very, very hands-off and very they've treated Treasury with very, very gentle gloves, because revenue is the life stream of government. And without the life stream of government, and without revenue, the government doesn't work, cannot work. So any action that other than certain designated actions, like in tax court for refund, you cannot bring if it restrains the assessment or collection of tax. Now, this has been interpreted extremely broadly, this provision, and it has been held by, in the case of Florida bankers with Judge Kavanaugh when he was at the DC appellate level, that basically this means you can almost never file an action which seeks to invalidate a regulation, a Treasury regulation, because if you do that and you succeed in avoiding the Treasury regulation, that many times results in the cancellation of the tax, and that by definition implicates the Anti-Injunction Act. So when we first started out and filed our lawsuit, every single expert, this was the big hurdle of a year ago. No one thought we could overcome this, because this had been interpreted by Judge Kavanaugh, who now is on the Supreme Court, to mean that you can basically never challenge a regulation by a lawsuit such as this. You have to file a refund action, and then you can challenge the reg when you're specifically, you paid the tax and now you're suing for a refund. Okay, so when we filed this our lawsuit, this was the first thing that every expert thought we would never overcome. Never. Every single expert. Okay, the biggest law firms in the world and the biggest experts all said not a chance in hell. The other reason they challenged us was that we lacked standing. Why? Because they said, listen, maybe Monty was injured in that he has to pay higher compliance costs or maybe even pay the transition tax. But that was caused by the law. It wasn't caused by the regulation. The law says he has to pay. So what does it matter what the reg does? The law is an independent basis for the liability. Okay? Those are two very powerful arguments. Okay? And I was certain that if we overcome this, we will win the case because the merits are much easier because the government just didn't comply and they certified wrongly. Okay? And when the judge on Christmas Eve came out with the ruling, I was ecstatic. And that's when this case really took on a life of its own in the media and with experts. Why? Because the judge basically tossed out their motion on the very broadest ground. So like even broader than I hoped for. Okay, what did that mean? He said, this is not a case about taxes. This is an administrative law challenge that says, Treasury, that you did not comply with your statutory requirements. Okay, this is not a case about tax. This is a case about administrative law. You did not follow the law. Monty is not seeking to invalidate any regulation. All he wants is to make you follow the law. And he didn't even mention the Florida Bankers Kavanaugh case. And this shocked experts because it was a bam. It was opening up a door this big or wide, saying to the world, you guys, you can challenge a lot of Treasury regulations using this law, and it is not bound by Kavanaugh's Florida bankers. When he said that, the tax world, the administrative law world, and the media community went crazy. Why? And they started publishing about this article, and it was cited here in the Supreme Court. So this is just to show you something where the case was cited in the Supreme Court very quickly, because it opened a door that had never existed before, and it basically opened up a way to challenge federal tax regulations, and that had never been done before. Never. You could not get around that Anti-Injunction Act. Secondly, he said, of course he had injury. He had to pay transition tax, or he had extra compliance costs. That's an injury. Treasury, if you had done your job and exempted him, he wouldn't have had that injury. It's a clear injury. The lawsuit can move ahead to the merits. Okay? And that was a day, then that was a really significant day. And again, I was sure, thank you, that the rest of the case would be easy because the standing and procedural issues were taken care of. And now we were at the merits where it was a slam dunk. And I was very confident, and I still am confident because we have a very strong case. Okay, so the judge, a Democrat, Obama appointee, liberal, private, what was he, a public defender, Nye, California, everything you wanted. He basically, you could see from the wording of the opinion that he didn't have much patience for the government's trying to get itself off on technicality when the merits of the case, he by then saw, were so one-sided. So he basically opened the door to a whole new area of administrative law. Now, that law, that ruling still is on the books. That ruling is still on the books, okay? So he has ruled that the RFA can get around the Anti-Injunction Act. That has not changed, and that is what a lot of the newspapers and articles were all about. We have won that battle, a very significant battle, and we have shown that you can sue Treasury under this law and proceed to the merits. That's a very significant thing we've accomplished, okay? But then what happened? Well, in March 21, the court heard our motion for judgment. We said, okay, well, we've won all the preliminary stuff, let's go to the merits. And here, The judge kind of shocked us, okay? How so? He did a 180-degree flip-flop, okay? Dismissing our case on jurisdictional and standing arguments that the government did not even raise. He by himself raised these issues that the government did not even raise, okay? And dismissed our case. As I said, the judge has the right to always look to see if he has jurisdiction, or he or she. But the government didn't raise those issues, and and so number one, he raised them. Number two, the way he did it is really an indication of that something had drastically changed. Okay, first of all, how did he get around getting to the merits? So he went back to the issues of standing and jurisdiction. Okay, he started by standing, redressability. He said, even if Monty, everything you say is right, there's nothing I can do. Okay, why? Because it was a one-time tax, and even if they didn't pass it, they didn't comply with it, how can I redress the problem? It's a past injury. And what am I supposed to do? Okay, and how can my order help you? Well, first of all, the argument is, look, the law is pretty clear. If they didn't comply, you must, by the law, issue remand and things like that. So he already was on looking at the law and kind of ignoring the law, which is the court shall, if I was injured. Okay, now he could have said, you know what, Monty, you have no future damages, so we'll just issue an injunction or a declaratory that you won. He could have done that. But then he also said, you also have no future injury because it's a one-time tax. I said, Your Honor, that's not true. I made the 962 election, which means that every time I draw a dividend out of that company, I'm going to be faced with really significant tax computations and more compliance. I'm going to be injured into the future. And the government didn't even dispute this. They said, oh, you're right, it's very layered, but the 962 election doesn't really have anything to do with the transition tax, okay? But I said, wait, Your Honor, look at the regulation. The government knew that people like us are going to be hammered by the regulation. And in the regulation, they talk about 54 places and 3 pages full only about the 962 election, and they expanded it knowing that it was a problem. How the government admits that it will impact us in the future, but they're saying it's not related, but it is related because it's the 962, the regulation, the transition tax regulation includes extensive discussion about the 962 election. And that goes into the future. The judge ignored that. So he talked about redressability. He, by law, has to do things if they didn't comply. But he started getting into this whole issue of redressability that no one knows where it came from, and it's not according to the law. Okay? The next thing he said, and this is this bullet, the RFA small business, that should be indented outwards. That's a standing argument. That's not a redressability. He said, wait. I want to understand something. Monty pays the tax. And so wait, who's covered by this regulation? Because for a person to have standing, they have to be protected by or impacted by the regulation. So Monty is obviously impacted by the regulation because he has to pay this tax conceptually. But Monty is a shareholder, and a shareholder is not a small business. A shareholder is just a shareholder. So Monty's not the business. So even though he is governed by the law, the transition tax law and regulations, he's not a small business. So therefore, he doesn't have standing because he's not a small business who's entitled to bring. But now Monty Silver Limited, the company, well, the problem is that the tax is paid by the individual. and the corporation isn't really covered by the law or the regulation. So, Your Honor, all the profits are in the company. It's the $2.5 trillion that all these foreign corporations were holding that the government was trying to get at. It is the company that has to do all the calculations and find out what it owes, what it doesn't owe, blah, 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 blah. It's true. The government, the individual, the individual pays it, but the company has to do all the work. The company has to pay out the money, and its money has gone away or it's being taxed now. How can you pick hairs, especially where the result is what? That I as an individual don't have standing, and I as a corporation don't have standing. So how could anybody in the world bring a lawsuit anytime that it's a CFC or a subpart F law and regulation? It will always be the situation that the individual is a shareholder, not a business, and the corporation who is regulated or has to pay all these taxes or funnel the money out is not covered by the law. I mean, by the transition tax, that makes no sense. And so you've created a legal impossibility that no one can bring a lawsuit under your analysis. And this is a liberal judge. And there was, in the ruling, when he came, he just completely didn't even mention the community. He just focused on Monty, ignoring the fact that hundreds of people emailed in comments, the Republicans overseas, Democrats abroad, they all did work. He was reading this, amicus briefs from Harvard. But the bottom line is the judge did everything possible in refining arguments and distorting arguments to come to the conclusion that we didn't have standing and that we didn't have standing for those two grounds, for redressability and also that we're not small businesses. This was a real tough one to justify in my view. Okay, so what are the next steps? Well, on the transition tax lawsuit, the next steps are very clear. First of all, does Monty want to go around and fight this? The answer is yes. Why? Because the case is super strong. I know it. The case is super strong, and there appears to be something else at play in this judge's at play here. So let's just go back. What happened between December 19th and 2019 and March 2021? What could have happened that brought about such a huge shift in the judge's perspective? Well, I can point to two things. Now, Biden is president, and the Treasury is run by Democrats. Number two, of course, even more important, is the pandemic. The American government is really, of course, in a chaotic state. And to rule in my favor on the merits would mean the Treasury would have to spend significant resources on this stuff. And the judge is looking and saying, pandemic, infrastructure, COVID, blah, blah, blah. And Monty and a bunch of expats. What do I do? Yep, King Solomon. Anyways, so that is what my analysis is. So motion for reconsideration, we will be filing. The chances are not great, they're very small, but it allows us to build a record for the appeal. I think on an appeal, the chances are good. I'm now a bit more hesitant to say that, but I see how flimsy that decision is. It reaches conclusions that are kind of hard to justify. And what is good is on appeal, all declaring all the bases, all legal analysis of the judge is subject to a brand new de novo, meaning from the beginning analysis. Factual factual things are factual findings are much harder to overturn. But here he is basically saying that as a matter of law, corporation is not governed by the law, by the transition tax, and regressibility, and those things are legal conclusions, and those are reviewed de novo. And I have a feeling that the judge basically punted here and said, you know what, let the people on appeal, one before the Supreme Court, let them decide. If they think Monty's right, they'll kick it back down to me, and then I have their certification that I can do what I want. Okay, so I think there was a punt here, that he just did not want to address this at this time, given the new administration and the pandemic. Okay. Now, what is the impact of this case on Gilfie? Well, on the redressability issue, our situation is much better. Why? Because Gilfie is an annual tax. So the judge cannot say, oh, it was a one-time tax and I can't address anything because whatever I do won't impact the future and won't help you in the future. That is not true. Because with Gilfie, by definition, it's an annual thing. Okay, so the argument on regressibility is far stronger, even though for nothing in the transition tax, the 962 was by definition a future injury I'm going to be suffering. Here it's by law, and it's in the regulations. It's an annual. It's a law. It's annual. Okay, but on the other hand, the judge can look at what the transition tax judge said on that neither Monty or the company have standing, and they can say, well, like Monty said, the Gilfie and the transition tax are kind of sister taxes. So why don't I just rule the same way on the issue of standing, that Monty and Monty Silver Limited don't have standing. Okay. That, of course, she can do that. It's a woman in this case. Okay. So what can they do? They can do that at the motion to dismiss stage, where we're at in the Gilfie, or they can do it at the summary judgment stage. There is uncertainty, but I know that myself and our lawyer, Mark Zell, who's Israeli-American, who is a lawyer in DC, a DC lawyer, he has decades of experience in litigating in the federal court in DC at the trial, appeals, and Supreme Court level. He's a fighter like I am, and he's an expat. We're both committed to seeing these two lawsuits all the way to the Supreme Court. What you do is you file an appeal if you lose the transition tax. And if you lose the appeal, you are allowed as a matter of right, meaning it's your right, to ask the Supreme Court to review it. Okay? They don't have to hear the case. Okay, but Mark and I are committed to seeing this through on a very small legal budget. Okay? So that is basically where we stand on the lawsuits. Now, what is happening regarding Gilfie in the future? Well, as we know, the Democratic Congress, the Democrats control all the three branches, the two houses of Congress and the presidency. They will be passing an infrastructure bill of $2 trillion, and they will pay for it by increasing the corporate tax rate and by increasing the Gilfie minimum tax, and by potentially eliminating the high tax exemption or leaving it as is. But if the corporate rate goes up to 28%, you only get the high tax exemption if your corporate rate is 25.2 or higher, which is very seldomly the case. What this all means is very simple, that unless Congress comes up with some de minimis or some minimum that you have level of corporate business that you have to have, so the size of your business, unless they come up with a minimum, then we expect are going to be part of this crazy guilty game for a long time to come, and it's going to get much harder because the minimum tax will be raised for sure 15, 18, 20%, we do not know. High tax exemption may go. The rules will constantly be changing, so we're going to be stuck with compliance, changing compliance, and it is bad news. There's no doubt about it. This is bad, bad news. What to do about it? Well, that is, there's two things that I can think of. One of them is winning this lawsuit, and the other one is lobbying Congress. And those are the only two ways I see to address this. So that is a summary of where we're at. Next steps, as I said, motion for reconsideration, appeal, guilty, all the way to the Supreme Court. And also, how do we get a fix, a legislative fix now that this is going to be raised in Congress, to how do we get a fix for this guilty pandemic, which is this really a plague, which is really harmful to us. That is it for now. Thank you very, very much for your support, and I hope you found this valuable. Bye-bye.